Hello, everybody. This is Joe from PrepAgent. I hope you're having a good morning this morning. Today's Saturday, and we're ready to go. We're going to do property transfer. If you guys can hear me, give me a thumbs up, and we will get started. Hi, Katie. Hope you guys are all doing well. I had a little bummer. I got my passport photo yesterday. Nothing reveals that you're getting older than your passport photo. Ugh. They take that picture in that horrible light, and you see every wrinkle and flaw you have, and then you get to compare it to your picture from when you were younger. Ugh. Anybody else get a passport photo recently? It's like the worst experience. Well, not ever. There's worse experiences. But I saw the picture, and I was like, ugh, really? And they don't let you take another one. They're just like, that's it. Done. One and done. Can't stand it. Anyway, so now we're ready to talk about property transfer. So when you talk about property transfer, all right, what is the most important thing? The most important thing is the deed. All right, what's a deed? Ooh, dolphins. Very nice, Mike. Love dolphins. Few animals connect you with nature like seeing dolphins. Okay, it's evidence of a transfer. Evidence of a transfer. Okay, so a deed is the evidence of a transfer. Good. All right, so you got the evidence of a transfer. 33%, if your video's blurry, just make sure you change it to 720 HD, and then it'll be more clear. Okay, so make sure you change the settings 720 HD. All right, so a deed is evidence of a transfer. Can you guys tell me what is a quitclaim deed? What is a quitclaim deed? So quitclaim deed is no expressed or implied warranties. Good job, everybody. Quitclaim deed is no expressed or implied warranties. Basically saying what you see is what you get. What's a warranty deed? Anybody know what a warranty deed is? A warranty deed has no express or implied, has express or implied warranties, which means there could be issues that you need to look out for. Okay, let's do the question on the board. Which of the following statements concerning the addition or subtraction of land is correct? A, erosion is the general decay of structures built on land. B, accretion is the gradual loss of soil through natural causes. C, erosion is the gradual loss of soil due to ocean tides. Or D, accretion is the gradual deposit of soil through natural causes. And the answer is D. Good. Property taxes are described as ad valorem taxes. Ad valorem most nearly means A, according to value, B, reproduction value, C, replacement value, or D, market value. What do you guys think? It means A, according to value. Good. Ralph sold his house to Oscar, who did not record the deed, but took residency there. Ralph then sold the same property to Larry, who received the county records but did not examine the property. Ralph gave Larry a deed, which Larry recorded. Which of the following would be true concerning title to the property? A. Larry and Oscar are co-owners of the property. B. Larry now owns the property because he recorded his deed first. C. Oscar maintains title. Or D. Larry has recourse against Oscar for failure to record. The answer is C. Possession and recording function the same way, so therefore whoever did it first gets the property. And because he took possession first, he gets the property. You guys going to some open houses tomorrow? I hope so. Open house. Do we have any new people on the webinar? Any first timers? Or is everybody returning spectator? Ooh. I've not looked at Netflix yet. I need to do that. Guys, got to go to those open houses. I say it all the time, and I can't say it enough. The goal is not passing the test. The goal is to make money. Passing the test is a step along towards that goal. So when you guys pass, you got to be ready. And part of getting ready is going to open houses, getting yourself out there, and learning from people. Okay, the marginal tax rate is defined as A, 22% of the gross income. B, the tax rate which is applied to the next dollar earned. C, the 29% tax rate. D, the tax rate which is applied to the last dollar earned. And the answer is B. Which of the following best describes earnest money? A, the money deposited by the purchaser with a broker or seller to pay for the expenses of examining the title. B, the money deposited by the purchaser at the time of signing the earnest money or sales contract. C, the commission paid by the broker. Or D, the consideration for the sale of the property. And the answer is B. Okay, so earnest money deposit, also known as a good faith deposit, shows you're serious about buying the property. Which of the following cannot be real property? A, a fixture. B, mineral rights. C, an existing mortgage. Or D, an easement. Okay, why would a mortgage not be real property? Anybody know? Why would a mortgage not be real property? Who knows the answer to that? Exactly, Yuri. It goes with a person. So a mortgage is specifically for a person. It does not go with the property. All right? I mean, if I sell my property to you, you don't take on my mortgage. You get your own mortgage. Right, guys? I mean, you could assume my mortgage, but that's written into a contract. But a mortgage is considered personal property because it goes to the person, not the property. The covenant in a deed which states the grantor is the owner and has the right to convey the title is called A. Covenant against encumbrances. B. Covenant against further insurance. C. Covenant of season. Or D. Covenant of warranty forever. And the answer is C. By the way, we all know why words are highlighted in the question, right? And so if you click on it, you can see the definition. I'm not sure if any of you guys realize that when you're using our program. When it's highlighted, it means it's a clickable link that could show the definition of the word. It's a nice little feature that Arthur built in case you guys weren't aware of that. Okay. Until the land contract is paid in full, what is the status of the purchaser's interest in the property? A. Purchaser possesses a legal life estate in the premise. B. Purchase has equitable title in the property. C. Purchaser has no legal interest in the property. Or D. Purchaser holds legal title to the premise. Purchaser's equitable title in the property. Good. Prepaid insurance and tax reserves in which the buyer assumes the mortgage will appear on a typical closing statement as A. Credit to the buyer and debit to the seller. B. Debit to the buyer and credit to the seller. C. Debit to the seller only. Or D. Credit to the seller only. B. It's prepaid, so therefore it's a credit to the seller. They pay in advance, they get that money back. So, Katie, a credit is when you get money back, a debit's money you owe. So if you pay the money in advance, so if I pay like $1,000 for the year and I sell it halfway through the year, I get that other half in the second half of the year credited back. I mean, that's not exactly how it works, but that's an example. On a settlement statement, prorations for real estate taxes paid in areas are shown as A. Debit both the seller and the buyer. B. Credit the seller and debit to the buyer. C. Credit to both the seller and buyer. D. Debit to the seller and credit to the buyer. I need my Starbucks drink. Who wants to go to Starbucks with me? Anybody? Anybody? Okay, the answer is D. Debit to the seller and credit to the buyer. Who's in California? Anybody in Southern California? Where's the Southern California people? A defect or cloud on title of the property may be cured by A. Bringing an action to register the title. B, bring an action to repudiate the title. C, paying cash for the property at the settlement. Or D, obtaining proof of satisfaction for all appropriate parties. Morro Bay, where's that? West Palm Beach, that's Florida. The answer is D, obtaining proof of satisfaction from all appropriate parties. New Hampshire. New Hampshire, a lot of flannel shirts and pickup trucks, I feel like. And maple syrup. That's Vermont. If Joe dies without having made the will, it is said to be A, intestate, B, improbate, C, attestate, or D, attestator. And dying without a will can make it intestate. And then there's a chance it could escheat to the state, right, guys? Escheat is one of the 4 government powers. What are the other 3 government powers? What are the other 3 government powers? Thanks, Mike. Enjoy the Dolphins. Okay, the other 3 government powers are police power, taxation, and eminent domain. So the 4 government powers would be police power, eminent domain, taxation, and escheat. Carol enters the sale leaseback agreement with Joe, under which will become the owners of Carol's ranch. Which of these statements is true of this arrangement? A, Carol is the lessor. B, Carol retains title to the ranch. C, Joe is the lessor. Or D, Joe receives possession of the property. C, Joe is the lessor. What is a sale leaseback? Anybody know? Who knows what a sale leaseback? Okay, a sale leaseback is when the vendor becomes the lessee. Is when the vendor becomes the lessee. Right? You sell it and then you rent the property you used to live in. Mm-hmm. When the grantor does not wish to convey certain property rights, he or she A, must note the exceptions in a separate document. B, must convey the entire premise and have the grantee reconvey the rights to be retained by the grantor. C, may note the exceptions in the deed of conveyance. Or D, may not do so since the deed conveys the entire premise. And the answer is C. May note the exceptions in the deed of conveyance. Miss Johnson owned an income property with adjusted cost basis of $150,000 and a fair market value of $200,000. She exchanged the property for another income property which had a fair market value of $210,000. Both properties had no loans against them and no adjustments were made for the differences in value. For federal income tax purposes, the new property will have a basis of Mrs. Johnson of A, $150,000, B, $210,000, C, $100,000, or D, $200,000. What do you guys think? Okay, and the answer is $150,000. Simply the cost base of the old property is now the cost base of the new property. Good stuff, everybody. David is a life tenant and later sells his estate to Joe. If David dies, what happens to the title of the property? A, it goes to Joe's heirs. B, it stays in Joe's name. C, it goes to David's heirs. Or D, Joe becomes the remainderman. And the answer is D, Joe becomes the remainderman. A bill of sale is used to transfer the ownership of what? A, personal property. B, real property. C, fixtures. Or D, appurtenances. Okay, so a bill of sale is there to transfer personal property. And as we started off today, a deed is used to transfer real property. So Danielle Bender, that you should just change to 720 HD and you'll be okay. If it's anything than that, it's a connection issue. What is true about restrictive covenants? A, they are voidable by successive owners. B, they are placed by government agencies in the public record. C, they are placed by private parties in a deed. Or D, they are placed by the government agencies in a deed. It's on the screen where you see the questions, Danielle. Okay, and the answer is C. They're placed by private parties in a deed. What kind of a lien is created as a result of a judgment estate or inheritance taxes? The descendants' debts are unpaid federal income taxes. A, equitable. B, general. C, voluntary. Or D, specific. What do you guys think? Okay, the answer is general. So what's the difference between a general lien and a specific lien? Who knows? What is the difference between a general lien and a specific lien? Any of you guys know? What's the difference between a general lien and a specific lien? Okay, general lien, they can take all your property. A specific lien, they take one thing specifically. Right, guys? So general lien, they take everything. Examples of general liens would be judgment liens, income taxes. Specific liens would be like property tax or mechanics liens, or when you get a loan on a house, things of that nature. When real estate under an estate for years is sold, what happens to the lease? A, it binds the new owner. B, it is subject to termination with a proper notice. C, it expires with a conveyance. Or D, it is valid but unenforceable. Good luck, Maria. Everybody wish Maria good luck. Okay, and the answer here is A. Finds a new owner. Which of the following would cause a license to cross a private property to terminate? A, the property was sold. B, the person with the license has not used it for 6 months. C, the person with the license has not used it for 1 year. Or D, the person with the license has not used it for 2 years. What do you guys think? There's A, the property was sold. Oh, congratulations, Danielle. Go get them. Nothing like buying what you're selling, unless you work like at a bakery, then you get like fat because you're always eating that stuff. Katie asks, is a license a type of easement? An easement's a type of license. I guess that's true. So a license is your ability to, it's your, when you're given a right to do somebody upon somebody else's land. Into an easement, you could cross that. So you have that right. So it just be a form of a license. In most states, by paying debt after foreclosure sale, the mortgage has the right to regain the property. What is this called? A, owner's right of redemption. B, statutory rights of redemption. C, equitable right of redemption. Or D, vendee's right of redemption. I have to get back to you on that one, Amanda. Send me a message to the site. I don't have Adrian with me today to look that up, but definitely want to find that out. It's a good question. Okay. So redemption is called statutory. Is legally mandated by law. Okay, so there you go. All right, guys, that's it for today. I have to do family stuff. So we're going to go now, and I hope you guys have a great weekend. Make sure you go to the open houses, and I will see everybody on Monday. Thanks, everybody. Have a good weekend.